Ms. Wedrick express yourself. Yeah.
The unique back and forth of Kansas law as it relates to the conversion of person felonies, specifically in the burglary arena of Missouri, is a very fun, exciting ride through the Court of Opinions rulings over the last few years.
Yeah.
I believe that Miss Areola, who composed the PSI, is accurately looking at the conversion as it would be today. But I believe the period in which these crimes were alleged, were convictions in Missouri, is during a period where they don't convert here.
I misunderstood that last part. What?
I think he's an E.
Okay. And when we have him down in your plea offer?
An A.
Oh, okay.
Your Honor, he has, a dozen res burgs, second-degree burgs in Missouri.
Right.
I'm not looking at the PSI in front of me. This is going off my memory, so a dozen is not meant to be a literal statement, but somewhere in that area.
Right.
Those convictions, and I've looked at the indictments from Missouri for all of them from Megan, because Megan was aware that this was a potential issue, and she erred on the side of caution here. And like I said, her analysis is accurate today. But I believe that all those second degrees, and actually the first degrees as well, all of the burglary charges, because of Missouri's language, requires any crime committed in the structure, and the res ones are simply an inhabitable structure as opposed to one used as a dwelling, which our law clearly delineates.
Remind me, about when did Wedrick change that?
Well, post the 2019 amendment would clear us. So
Right.
Since the amendment in 2019, we're fine.
But
This would be
all
accurate,
happened.
but these are all old.
Yeah.
And then would go under that preceding analysis. And not to think for a second that the court would want to go over my head here, but I went over my own head to Daniel Obermeyer, and his interpretation is the same, only it sounds far more convincing.
Yeah, no, I think you're both right. I was just looking at the time frames. All right. So if he's an E, let me flip this back right now. Whoops.
I think it drops 30 something months off the exposure.
Yeah, I don't have my grid right here in front of me.
Well, you have to let me out of your sharing screen. You lock up our screens when you do that.
Yeah.
But I have it up on, let's see here.
Miss Johns, if he's an E for this, what's his range going to be?
246, 234, 221.
Okay.
It's a drug one.
I was looking at the wrong one. I'm sorry. Looking at the wrong one.
154, 162, 170.
70. Yeah. Sorry about that.
546270, Judge.
Yep. All right. Same presumptions, obviously.
And our deal, though, was for a percentage of the time, so this would affect the defendant here. Obviously, this would lower his time there, and that was the deal we crafted. So I think that's fair.
Right. All right. Okay. Go on the record here.
Your Honor, is there any noise disturbance? I can't tell if you can hear. I have some work being done upstairs. I've been banished to the basement. I just didn't want that to disturb anybody.
I have not heard anything.
Okay.
Yeah. All right. Let's be on the record. Case number 2019-CR1231, caption State of Kansas versus Jamal Benton. Would the parties announce their appearances, please?
May it please the court, the state of Kansas appears virtually through Assistant District Attorney Adam Sokoloff.
Please the court, Albert E. Grauberger appears for the defendant, Mr. Benton.
All right. We are here set down for a sentencing today. I've received a PSI and reviewed the same. There were some comments before we came on the record. It appears well, I wouldn't call the PSI this a mistake. The parties were aware that with the operation of the state v. or Wettrick v. State in Kansas, that there's been some changes to how to count out of state felony convictions. And frankly, at this time, all of the court believes that all of Mr. Benton's Missouri convictions there would, given the change in the statute, qualify as scored. And the PSI writer wrote that as such. However, I think the case's law is pretty clear that we are to apply the law as it was at the time of the commission of those crimes, which in Mr. Benton's case was back in 09 through 12, I believe, all the ones that we're talking about. So those couldn't convert to person felonies and therefore can't be scored as such. So I think the parties agree that the accurate criminal history score based on that ruling today would be a criminal history score of E as in Edward, leaving the defendant with a presumed range of 154, 162, or 170 months. The presumption for prison would still apply, as would all the other findings. I would ask you, Mr. Sokoloff, before we begin, do you agree with the court's recitation of what the parties believe the situation?
Yes, Your Honor, the state concurs. We believe those Missouri burglary convictions would convert as non-person felonies given the time frame when they were in. And I know that Ms. Areola, who composed the document, was aware of that issue, wanted to err on the side of the caution and allow the court to make that determination. But we were prepared for that, and that is our opinion as well.
My guess is, Mr. Grauberger, that you would not object to that and you agree with that as well.
Not at all, Your Honor.
All right. So I'm going to amend orally today the pre-sentence investigation to score those Missouri burglaries as non-person felonies and therefore change the criminal history score to that of E with that sentencing range that I mentioned before. With that change, the critical, I should, I guess, give a brief recitation of the history here. The parties appeared in court back on July 20th. And at that time, the defendant changed his plea from one of not guilty to guilty to manufacture of controlled substance or controlled substance analog, which is a severity level 1 drug felony. As I said, the criminal history score now reads as an E, which would leave him with a presumed range of 154, 162, and 170 months. That sentence is presumed to be one of prison. If he has to do that time, he'll be eligible for 15% good time credit and subject to a post-release supervision duration of 36 months. If he were granted probation today, it would be to community corrections for 36 months. Mr. Sokoloff, with all of that, any objections, challenges to the PSI today?
Beyond what we've discussed, Your Honor, the state has no amendment or corrections.
All right. Mr. Grauberger, same question.
No corrections.
All right. Mr. Benton, we've been talking about a lot of stuff here. Nobody's even addressed you. Do you understand what we're saying today?
Yes.
Okay. So the criminal history, as Mr. Grauberger probably went over with you, actually by operation of law should be much lower than it appears. You're a criminal history E, not an A for today's purposes, which roughly cuts off about, I don't know, let's say for the presumed sentence anyway, about 30 some odd months, almost 3 years. You understand that?
Yes.
All right. So with those changes that I've already mentioned ad nauseum, I will adopt the findings of the pre-sentence investigation. Mr. Grauberger, I believe you filed a motion for a dispositional departure. I'm not able to get on my chamber's computer today. Is that correct?
Yes.
All right. Would you like to be heard on that today?
Well, I would ask Your Honor, based on my conversations with my client and his past history and his new items that have just come up, that his sentence, which is in the plea agreement, was 81 months, be reduced accordingly to the new findings from an A to an E.
All right. Mr. Sokoloff?
Yes, Your Honor, the court, I'd ask the court to follow our plea agreement, which we believe it, all things considered, is in the interest of all parties. There's obviously a significant benefit to Mr. Benton in entering into the plea in that he's going to effectively cut his time in half, a little better than half, I think, ultimately, with how we agreed to do it. It's also good for the state because it avoids us having to expend the resources and go through the time, especially given the pandemic, of going to trial and bringing in a number of witnesses, both law enforcement, fire department, and civilian. And so by taking responsibility for his actions and pleading guilty, we believe it's warranted that this plea deal be entered into. I would just mention, Your Honor, that by operation of law, the aggravated endangerment charge runs consecutive to the controlling charge here, but that is something that Mr. Grauberger prepared for in our negotiations. And I don't have the plea petition immediately in front of me, Your Honor, but I remember my intent was to make it so that the controlling term recommended to the court would equal 50% of the E box standard and not be exceeded by the aggravated endangerment term. So I would ask the court to take 50% of the E box standard for the one, subtract the consecutive time that would have been added for the ag endangerment charge, for the controlling term to be the 50% number. I feel like I maybe didn't articulate that as well previously, and I wanted to make that clear for everyone's sake. And certainly Mr. Grauberger could correct me if I was wrong, but that's our intent, Your Honor.
That was
All
good.
right. And I did fail to mention the secondary charge in the PSI, which was aggravated endangerment of a child, criminal history score of I for scoring purposes, which would leave him with a presumed sentence of 5, 6, or 7 months. The presumption of prison would, from count 1, would flow to that. And the special rule that Mr. Sokoloff noted, number 35, that it is mandatorily consecutive. Mr. Grauberger, any objections to those findings?
No, Your Honor.
All right. All right. Mr. Benton, now is your opportunity to tell me anything you want me to know in mitigation of your sentence today.
I have nothing, Your Honor.
All right. I'm going to follow the plea agreement and sentence the defendant thusly. For count 1, the manufacturer of controlled substance, criminal history score E, he will be sentenced to a period of 75 months in the Department of Corrections. For count, he's eligible for 15% good time credit, subject to 36 months of post-release supervision duration. He's not applying for probation. Probation would not be appropriate in this case, and it will not be granted. As to count 2, he will be sentenced to a period of 6 months. By operation of law, that sentence must run consecutively to count 1, and it is ordered to do so. Again, he will be subject to 15% good time credit and 36 months of post-release supervision duration. All right. A couple of questions. Oh, I'm sorry. In granting this durational departure, I find the following substantial and compelling reasons to do so. The defendant has accepted responsibility for his crime, and he has saved the state and their witnesses substantial amounts of money and time in not pursuing a trial in this matter. And I find that is sufficient to grant this durational departure today. All right. Would somebody advise me? I think this is a registrable offense. Is that correct, Mr. Sokoloff?
Yes, Your Honor. Level 1 manufacturing would require registration.
Right. All right. So a couple of things that I need to advise you of, Mr. Benton, you have 14 days from today to appeal anything you don't like about your sentence. As a convicted felon, it's prohibited for you to own or possess a firearm, certain kind of deadly cutting instruments like dirks, daggers, switchblades, basically knives that could be considered weapons. I won't go through the whole list. Just know that when you get out, before you decide to own or possess any kind of weapon, make sure you talk to a good lawyer like Mr. Grauberger to make sure that it wouldn't cause you further legal troubles. You are required to register. Upon your release, you will have 3 days from your release to register with the sheriff of the county in which you're going to reside, and then follow the registration requirements from that point forward. Mr. Benton, do you have a occupation that you normally pursue when you're not in custody?
No, sir.
All right. So how do you make ends meet?
I was a dishwasher. I worked at a dry cleaners.
Okay. All right. Are you planning on, I assume, getting back and being employed when you get out?
As of right now, I was thinking about while I'm incarcerated, doing some type of plumbing program so I can get a trade.
Good idea. Be a good use of your time. All right. So I think there's no reason to believe that the defendant wouldn't be able to be fully employed in fact, that would probably be part of his post-release supervision. So I'm going to order court costs be assessed in this case. And I'm not making those due during the period of his incarceration. Mr. Sokoloff, were any of the components tested in this case where I have to order the KBI lab fee?
Fortunately for us, no, Your Honor. The fire department has on-site testing capabilities, and we didn't get to the KBI level, so we would not be asking for that fee.
All right. Defendant has, let's see if he has prior Kansas felonies. It's been a while since I looked at the criminal history. All right. That's a misdemeanor. They look like all Missouri felony convictions. So I think I do have to assess the DNA database fee, and that will be assessed. There will be no fine in the case. So simply court costs and DNA database fee will be assessed versus the defendant. I think he should be able to meet $150 a month once he's out to get that cleared before he's off paper. So that will be the court's order. All right. So having covered all of that, Mr. Sokoloff, are there things today that I've failed to cover?
The only thing, Your Honor, I just don't know for my journal entry purposes for the parties. I don't know if counsel's retained or appointed, and if he was appointed, then the court might address that.
Oh, yeah. I think, Al, you were appointed in this case.
I am, Your Honor.
Yeah, I'm going to waive his attorney's fees and the bid's application fee. Mr. Benton's going to have to be owing some money as it is, trying to get back on his feet. I don't want to overburden him, so I'll waive those. I'll certainly submit your voucher and it'll be approved.
Other than that, Your Honor, that was the only thing I could see on the journal entry. I think we're good otherwise. Thank you.
All right. Al, anything you think I failed to cover?
Well, the only thing is that you said you were going to make a downward departure, but I don't think you stated the period.
I did. It was a 75-month underlying sentence for count 1, a 6-month sentence for count 2, and those were ordered to run consecutively by operation of law for a total of 81 months.
Okay, that was the plea agreement based upon an A. I would ask Mr. Sokoloff if that should not be adjusted.
That was a plea, as I recall the plea petition, it was contemplated that he was going to be an E and 50% off the E sentence, which would be 162 months, 50% of which was 81 months. If he was in fact an A, and it was contemplated off of that, the underlying sentence would have been somewhat higher. It's looking at like 90, what is that? 97 months would have been the number. Mr. Sokoloff, do I have that correct?
Yeah, this is 1/2 of the E, Al.
I think you're both correct. I'm just trying to get as much as I can for my client.
Sure. All right. So that's the sentence. All right. Anything else for our record today?
Not
Nothing
from the
from the
state.
state.
All right. Mr. Ben, good luck to you. I encourage you to seek that trade program while you're in custody, and hopefully you can get out and get this all behind you, okay?
Okay.
Good luck to you. We are adjourned, everyone.
Thank you, Judge.
Thank you.